Welcome to Legal Lines. I'm your host, Glenn Smith. The power to pardon. It's been in our state's constitutions dating back to 1776 in one form or another. In fact, the power to pardon predates our state's constitutions and can be traced to the Charter of Pennsylvania, where William Penn received from Charles II amongst the land the power to also provide pardons to all criminal matters, short of treason and murder. Our early constitutions here in Pennsylvania have provided our governors exclusive and unfettered access to grant pardons for criminal matters with the exceptions of impeachments. However, due to allegations of abuse, whether it was real or whether it was imagined, in 1872, our state's constitution was amended with the creation of the Pardons Board, limiting the executive branch's powers to pardon. Those limitations remain today. Fast forward to 2020. We had 723 applications submitted to the Pardon Board. Of those applications, over 85% of them were referred to the governor for some form of relief. Governor Wolf granted 85% of those applications submitted to him some form of relief or another, which was a 30% increase from the year prior, largely due in parts to a program for nonviolent marijuana-related offenses, a law that went into effect in September of 2019. Here to help us better understand pardons, as well as the expedited pardon process for nonviolent marijuana-related offenses, is attorney Susanne Smith. Susanne, welcome.
Thank you, Glenn.
So Susanne has been a practicing attorney for 29 years here in York as well as Adams County, and she primarily focuses on criminal law from summary to death penalty cases, but also has a practice in family law, protection from abuse, and unlimited civil practice. She's been representing clients in pardons and expungements for almost 20 years. She's been active in the York County Bar Association for a number of years, holding the position of president as well as secretary for the York County Bar Association Board, and she's active on a number of committees as well. She's also active in the Pennsylvania Bar Association, serving on a number of committees in that organization. She is currently a director and concluding her term with the West York School Board, and she also teaches a course on criminal trial advocacy at Gettysburg College. All right, so Susanne, once again, welcome to the show.
Thank you, Glenn.
Let's go ahead and ask the first question. What's a pardon?
So pardon is when you've filed an application and you're asking the board, in our case, as you noted, the change, we're asking our 5 members of the board to consider basically forgiving you of the offense that you've been convicted of. It's not for serious offenses. It's for your average, as you noted, not for homicides or murders. I don't want to say that there's not remedies or things for those people to do, but generally the pardon would be for the less serious. And the 5 members of the Pardon Board review that application, and if they think that it's appropriate, they're going to send it to the governor, who then gets to make that final decision whether to grant that pardon. And if that pardon is granted, it's as if you were never convicted.
Now, the focus of today's program, and you alluded to it a little bit, is there's a number of forms of relief that are out there in Pennsylvania. However, the one that we're talking about today is this expedited process that was put in place back in September of 2019. What types of crimes fall under that or have the ability to go through that expedited process?
So the expedited pardon was created specifically for marijuana-related offenses. So it could be your misdemeanor possession, small amounts, could be your possession, your felony possession with intents, anything that you were convicted of that's marijuana-related, even a marijuana-related DUI. They will give you the option, and the application has a section where you can check expedited pardon. So if your offense is marijuana related, you should check expedited pardon, and assuming it fits that criteria, they're going to move it on an expedited fashion, and they're going to speed up that processing.
So we're going to talk to our viewers a little bit later about the application process itself and where that box is to check off on it. But for the marijuana-related offenses that the expedited process is for, are there any exceptions to that?
I know some people might have more than one offense, like they could have a marijuana offense and then something not marijuana related. And then it'll be up to the board whether or not to accept that specific, like to add that into that non-marijuana charge into the expedited section. I think it's left up to the board whether or not they're going to view it as an offense that fits under that expedited section. They specifically listed marijuana-related offenses.
So we'll talk about it a little bit later, but is it fair to say that the board does have some flexibility in the way that it looks at each case that's presented to it?
That's my understanding, because they have indicated, and I don't know if I spoke with someone up there or if it was on their website, that indicated if you had your marijuana-related offense and then maybe something else, something minor coming along from an unrelated case, they can decide whether or not to allow or to allow the whole application to move into the expedited fashion. They can also decide that it shouldn't be in the expedited pardon, and they can bump it back to the regular pardon. So it doesn't mean you don't have relief. You just might not get to go in the expedited fashion.
Just by virtue of the program as we were describing it, it's non-violent offenses, so anything of a violent nature would not, even if it is marijuana related, would not be able to go through that expedited process.
It probably would not make it through. I think the background is the expedited pardon it's going to move quicker, and generally there aren't like true victims in these types of crimes, and so there's less, they don't have to reach out to people that could be impacted by your pardon. I mean, they would notify the DA's office where the crime occurred. They may notify the police, or if they choose, the DA's could seek that out. But there's not normally a victim per se of like a theft crime where that person would also be reached out to and notified.
That makes sense. How about if I had a marijuana-related case and I previously went through the ARD program? Is that something that I would be able to apply for through this process?
The hope is if you went through the ARD program, your charge through that program got expunged, and you should not need to have your charge pardoned. It shouldn't show up anywhere if it was expunged appropriately.
What about if my case is still ongoing? I haven't finalized my case, whether it's I haven't been sentenced yet or I'm still going through an appeal process, perhaps at some of the higher courts.
If your case is active in some fashion like that, most likely you're not going to want to apply for the pardon, nor is your application going to be accepted because it's ongoing. Part of the pardon process, you can apply for a pardon if you went to trial and you were convicted, or if you pled guilty. You can apply for a pardon in either of those circumstances. But generally, if there's something active actually happening with your case, your case is not really ready for a pardon. If you have been sentenced and you're serving a sentence, you might be eligible to start the process. It just kind of depends how far along you are in that sentence and what you have done. I usually kind of chat with clients on a case-by-case basis to determine if I think that they're ready. I know the general guidelines for the pardon board is 5 years should have passed since you've were pled guilty or found guilty of your misdemeanor, or 10 years for a felony.
So we've talked a little bit about who is and who is not eligible for this expedited process. Why would I want a pardon? What benefit is there to doing this? I've already gone through my case. I've been found guilty, or perhaps I've pled guilty to something. How's this going to help me?
So that's a good question, because depending on what you do, what your employment is, what your housing is, if you're in college, if you're wanting to go to college, your convictions could impact your ability to move forward. Your employment. A lot of jobs will not allow you or cannot allow you into their business if they have a federal contract. They can't usually hire people with felony on their record. Education, nursing, they don't really want any convictions, especially if it's any kind of drug-related conviction or anything of violence. So your record could impact you in ways that you don't necessarily anticipate or know. Housing, you could be evicted from housing with certain convictions, and felonies are usually a big part of that. The military doesn't always want you if you have certain convictions, again, especially with felonies. So you may not know what the impact is, or you may start to feel the impact as you're out in the job world. A lot of clients have also told me they can't advance beyond a certain point in their occupation or their career because of their record.
How about right to possess firearms?
Yes, your conviction and can impact your ability to possess a firearm, and the pardon board is aware that that is one of the reasons that some people do seek a pardon. I would emphasize that that should not be your only reason. You want some other reasons in addition to that. It's certainly important, especially in central Pennsylvania. We have a lot of hunters. And so that is something significant to them. But you should have that could be one reason along with others.
As somebody who holds public office, what about that?
Depends on the job, I guess the description, but yeah, I think a felony can impact certain positions being held by you, and I do know it pops up. It may not make you ineligible, but it could be something that becomes of interest to people when they're deciding whether or not to vote for you.
All right, so it's obvious. There's a lot of roadblocks that can be eliminated if you're successful going through a pardon process.
Correct.
All right, so I've decided I want to do a pardon. Is this something I can do by myself, or do I need to hire an attorney?
So it depends on you. Some people are really good at navigating the legal system and tracking down documents, but as a lawyer, I always encourage people to hire a lawyer. I've been hired in two capacities, either to complete someone's pardon for them with their assistance. I've also been hired as someone to be consulted with to kind of walk them through to make sure they're covering everything and they're kind of doing it on their own. It depends on your own comfort level. But again, as a lawyer, I encourage everyone to get a lawyer. You wouldn't operate on yourself, so, you get a doctor. I say this is a legal matter, get a lawyer.
Fair enough. So generally speaking, there is no requirement to have an attorney. However, if the applicant is currently incarcerated, it's necessary in that case for them to have counsel at that point?
Yes. If you are seeking some kind of, if you're incarcerated on a sentence, to become eligible, you usually have to hire a lawyer because you can't do a lot of this stuff on your own. And if you're seeking a commutation or a clemency, which is kind of like a pardon, but you're asking maybe for a life sentence, you're asking your sentence to be commuted so that you can get released, they will require you to have a lawyer in those situations.
And I guess it's probably important to mention about in making a decision whether you should be represented or whether you do it on your own, if you don't get the application right and it gets rejected, you're prohibited for a period of time of refiling. Is that right?
So if your application is not complete, they're going to notify you and give you some time to fix it. They will, allow you, but your application is not moving while it's sitting there if you don't fix it the right way, if you don't have the right documents. If you're rejected from a pardon, then you're going to have a time frame that you're going to have to account for.
Okay. So we're going to be taking a break here in just a second. When we come back, we're going to be talking about the application process itself. But if you are interested in finding that application, and I believe we're going to have it down here on the bottom of the screen, you can go to the Pennsylvania Board of Pardons website, which is www.bop.pa.gov. It has a lot of information. It's actually very informative, and the application can be found on there. So we'll be right back. All right, and we're back. Welcome back to Legal Lines. I'm your host, Glenn Smith. We're talking pardons. And with us today is attorney Susanne Smith, helping us understand the pardon process and the expedited process for nonviolent marijuana-related offenses. All right, Suzanne, so we've been talking about pardons. Let's get into the application. So does it cost me anything to file an application?
So there's no fees with filing the application or mailing the application or having them process the application. The only fee you're going to have to pay if you don't have the documents that they require you to attach and send along with your application. And you're going to have to pay for those at the county where the offense occurred and whatever fees they charge for those copies.
What kind of documents are we talking about?
So they require that you send your criminal information, your complaint and affidavit, and your plea or trial verdict. If you plead guilty, it's going to be a form or a little transcript that says, you know, what you pled to. If you were found guilty, there'll be a jury verdict, and then a sentencing transcript and form that says what you were sentenced to.
Now, it's also important to provide documentation that you've actually completed whatever it is you were sentenced to, right?
Correct, right. And you have to show that if there's costs associated with criminal cases, you also have to show that either the case is paid off or that you're in the process of making regular payments. Proof of completed payment or proof of a payment plan is also required with that application.
So if I had, let's say, a case that I was found guilty in Philadelphia, and then there was one up in Erie, and maybe another one over in Allegheny County, I've got to go or contact each of those counties to get all this information.
Correct. And every county is going to run a little differently. Some might allow you to send a letter to them requesting the documents. Some might let you email them. Some might require you to appear in person. And so, you know, you want to reach out to each county. You want to request all those documents, and hopefully you're able to work it out with them. They'll charge you whatever nominal fee. And then if a document doesn't exist, which in some situations documents are gone, they were never made, it disappeared, maybe, you know, flooded out, whatever, you have to get a letter from that county saying this document no longer exists, and you'll include that in your packet when you send your application.
You earlier said that the board not necessarily requires, but prefers that a case be at least 5 years old. I guess from the converse, which made me think about what you just said, the case might have been lost, could have been something from 30 years ago. Correct. I can still apply for something that old.
Yep, yeah. And people sometimes ask, do I need it? I don't know if you need it. Only you know in your individual circumstances if you need that pardon. I have some people that they just don't want it hanging over their head anymore. And so they want to clear it up and get rid of it while they're still alive. And other people have a change in occupation. And even though the record's really old, the record still exists. And so it can create havoc for you. And so that's why the process exists.
All right, well, let's get into the application then. So I went ahead and printed one out.
Okay.
The packet's
Good.
17 pages long. Now, I will
Yes.
tell you, the whole entire application is not that long, but there's a lot of information
Right.
in here about how to do it. So if you haven't already, go ahead and check that out on the website we previously provided.
And as you noted, you can download it. You just need Adobe to download it and print it, and you're ready to go.
Now, I can submit this application electronically as well as putting a stamp on it.
You have to mail it. All applications have to be mailed along with all the required documents.
Okay. So going through this application, it does require a fair amount of information, but right on the first page in section 1, that's where that box is you mentioned before that I have
Right.
to check if I want that expedited process. Because if I don't check that box, even if it's a nonviolent marijuana-related offense, that doesn't mean that it's going to go through the expedited process.
And you definitely want to, if you have a marijuana-related offense, you definitely want to try to do the expedited review. It's going to cut your processing time probably in half. You know, what was taking a number of years ago, it was 5 years, and maybe it dropped to 4 years. But the expedited process, I've seen it about 2 years.
Okay. So going on with this section 2, it's got applicant information. That's pretty self-explanatory. Names, dates of birth, things of that nature. But there is a box in there about representation. As we mentioned before the break, it does note there that all confined applicants must have representation, as they cannot represent themselves if granted a public hearing. And we'll get to the public hearing thing
Right.
in just a little bit. I thought I read in some of the literature on these pardons that if I choose not to hire an attorney to represent me through this process, I could have a family member or a friend or I don't know, my neighbor
Right.
represent me at this hearing.
They can assist you because it's not before a court, it's before the pardon board.
Okay. So it's not one of those areas that you have to have an attorney.
Correct.
Okay. All right. So we get into Section 3, which are the convictions that I want relief for. And as you mentioned earlier, if I don't put it in there, I'm not going to get it. So I have to make a decision what I want at this point.
So I tell everybody, if you, whatever you're convicted of is what you should seek to have pardoned. There's no sense picking and choosing. If you are eligible for 5 cases, you should apply on 5 cases. Because again, you never know what it is that is prohibiting you or preventing you from moving forward. And you're doing one application, you might as well just do everything. And they anticipate, as you can see on the top of Section 3, it says case number 1, oldest case. But as you go through, they actually have 3 pages for case 2 and case 3. So those are separate cases. You might have multiple offenses in each case, but you keep the offenses with one case, and then you go to the next case and you put the offenses in there. And we're specifically talking about convictions. You might have been charged with burglary, theft, receiving, and conspiracy all in one case, but maybe you only pled to burglary. Then the only charge that's going to show up in this case, conviction-wise, is a burglary. Non-conviction offenses, the pardon board does not look at because they are pardoning you for convicted offenses. So those offenses, you would either file for an expungement or a limited access, either prior to or while this is going on.
So in Section 3, where they're requiring the case information, is this a section here where I can plead my case about why I should get this relief or why this was wrong or how I was unwrongfully convicted?
Right. So if you've pled guilty, you should be admitting to what you did and pleading guilty and explaining what you did, how you were caught. It's not a time to minimize your offense. If you went to trial because you were not guilty or you believed you were not guilty and you were convicted, then you should explain what happened. But the pardon board is looking for people to accept responsibility and take responsibility for their actions. So the guilty pleas are the easy ones. The trials, again, if you believed you were not guilty but you were convicted, you're not going to really be accepting responsibility. And I'm not telling you to lie to the pardon board. I want you to be truthful, but this is the part where they want to hear from you. And this is the part where you're kind of saying, I did it, I'm moving on, and now I'm asking you to give me a pardon.
That makes sense. And I would also note, and here I highlighted, in fact, because I thought it was an interesting question, is in that section it asks, how were you caught? Mm-hmm. Again, be truthful, be honest with what happened. All right.
And there's supplemental pages that are also part of the original packet, and you can go and you can print those supplemental pages because they don't want anything other than their formal application being used. So you literally, everything that you need to get that application in is on that website.
Let's go on to Section 4. And I'm going to read the title of this because I can see how this would be a little misleading for some people.
Yeah.
And what it says is optional. In fact, optional is in all capital letters. It's the only word on the entire page that's in all capital letters. Optional personal statements. Is the personal statement, in your view, really optional?
I never would view it as optional. You just spent however many pages explaining about your criminal activity, and you've had to provide all those required documents explaining what you did, how you were caught, what happened to you, and now you're given this opportunity to explain why you should be granted this pardon. This is your chance to talk about all the good things you've done in the community, that you satisfied your conditions, that you have attended AA for the last 25 years, that you helped your grandmother with getting to the grocery store every week for the last 10 years. This is the time to sell yourself to the board and explain why you deserve your pardon. So I don't view it as optional. I view this one as important as the rest, if not more important.
Now, in this personal statement, in fact, the application gives 4 prompts here for specific things that they want to hear from. And those are how your life circumstances have changed, the reason you're seeking clemency, the reasons you feel you're a good candidate for consideration, and information you feel supports your request. Many of those things are things that you talked about already. Are there other things that I can do or add to this statement that you think are critical for the board to consider?
Yes. In addition to this written narrative of why you deserve it, and the background on this is the old application was much more complicated and actually had these areas kind of where you answered those specific questions. So I'm sure now this is much better. You get a little narrative, you can explain. But in addition to writing these things, you may want to attach certificates showing, you've done the treatment that was required, or you've done additional retreatment, or maybe a letter from a counselor saying you successfully completed anger management, or letters from your friends and neighbors who can speak to your good character. So in addition to this, you should attach these documents. Maybe you were Employee of the Month a couple of years ago. You want to put that in there too. Anything that shows that you've been a positive member of this community, now is the time to sell yourself.
So it seems to, something that sounds so simple, but the next section is the signature page. And it's important to read that signature page before you sign it, right?
Correct. You should read everything before you sign it, but yeah, you want to make sure you do exactly what they tell you, and review everything, because I think they do remind you to attach everything and to sign it saying you've been truthful in your answers and you've done everything that you've needed to do.
So let's say I go ahead and I submit my application, and then all of a sudden I realize, oh my God, I made a mistake or I forgot to include something. Am I out of luck?
No, you can send your corrections, amendments, changes, maybe additions to the pardon board at any time. And they'll periodically send you a letter confirming that they have received it, that it's being processed, that it's deemed filed, and they'll remind you that if things have changed or if you want to add something, now is the time to send it to them. And the one thing that you have to remember, name and address, and contact information. They have to be able to contact you. If you move, you need to notify the pardon board.
Keep it current.
Because they're never going to be able to track you down if you don't.
All right, so let's get to the pardon board itself. We just mentioned earlier, there's 5 members of it. The 2 standing members are the Lieutenant Governor, the Attorney General.
Correct.
And then there's 3 appointments from the Governor as
Correct.
well, right? So there's a victim representative.
Yep.
We've got, let's see, corrections expert, and then there's a doctor, medical professional. In this case, there's currently someone with a psychological background.
Correct.
Okay. So I've submitted my application to them. Are they the ones making the decision?
So they are going to make a decision whether to give you a merit hearing. If at least 2 of them say yes, you'll be scheduled to come in for a hearing, and then after that, the governor will make the final decision after hearing all this information, and there's an investigator out there as well confirming everything you've given them and maybe getting more information.
Great.
But the ultimate decision is the governor.
Okay. Well, we've run out of time for our program here on pardons. If you wind up following us on Facebook, we're going to have a little extra session here as far as the rest of the program. So check us out at the York County Bar Association for more information. You can also contact the York County Bar Association for legal representation, whether it's pro bono or a lawyer referral. Again, you can follow them at the YorkCountyBarAssociation.com. My name is Glenn Smith. You've been watching Legal Lines. Thanks for joining. Okay, we're back for our extra footage on pardons, so thank you for joining us. Once again, we're talking pardons here on Legal Lines. I'm your host, Glenn Smith, and our guest is Susanne Smith. So Susanne, where we left off was in the application process. We've officially submitted our application. It's now with the Board of Pardons.
Right.
What happens?
So the Board of Pardons is going to send you a letter acknowledging that they have received it, but it is not deemed filed, just that it's been received, and they're going to review it to make sure it has everything. If something's missing, they're going to notify you, tell you to fix it, get what they need. If you didn't send the right documents, if something's missing, if an answer doesn't seem to fit with the docket or whatever it is that they have, they're going to, again, ask you to correct it. Once it's reviewed and processed, at some point they're going to deem it filed. Once it's filed, then they're going to let you know that a investigator of some sort, state parole officer, or some person in that field is going to be reaching out to you to have some sort of meeting. It could be in person, it could be over the phone, and they're going to review not just the contents of your application, but they're going to basically get a summary of your life. They will send you in advance a list of the documents and things that they want to talk to you about, whether you rent or you own, whether you are financially stable, whether you're married, whether you belong to organizations. They're doing a life history on you, and they're going to prepare a report and give that to all the members of the pardon board, the 5 people we talked about, so that board will then have that investigative report and your application. And if you've added to your application at all, they'll have that information as well. If something's changed for you, if you got some kind of promotion or completed some training, you want to let them know that. Those are good things. So you're going to send that up to them as well.
What if I provided recommendations or referrals or letters from friends and family? Would I expect to have them contacted as well?
I don't know that answer. I have told people that if you are asking someone to write a recommendation letter for you, you should tell them they should be prepared to be contacted. And I have not heard either way whether or not someone has, but I always tell people, make sure they put a name and a phone number and an address so that the board member, the investigator, could reach out to them if they wanted to.
It probably goes without saying, but we're going to say it anyway. Safe to say honesty is the best policy in these investigations.
Right. And you want to make sure that those writing letters for you on your behalf, they know why they're writing a letter. And they should be prepared to hear from someone from the pardon board, because you would want them to be able to honestly say, yep, I know everything. That's why I wrote the letter, and I think they deserve the pardon.
So our investigation's complete. The investigator's done his or her job, submitted a report to the pardons board. Now what happens?
So now the pardons board is going to decide whether to grant you what's called a merit hearing. And the merit hearing is, well, it used to be in person. It's been by Zoom now. But those, if 1 or 2 members say, yeah, we want to hear more from this person, then you're going to be granted this merit hearing. And then they're actually going to hear from you. They may have specific questions. There might be one of the members might have something that they want to know, and that's why maybe they didn't vote for you, or maybe they did vote for you. But the decision whether to grant you a merit hearing is not the same as the decision whether to recommend you for a pardon. This is the next step. And at that time, at that merit hearing, they will make a decision following everybody's merit hearing. It's not all, one day you go up or you have a Zoom. It's everybody. They have set days. If you check out their website, you'll see when they have scheduled merit hearings. And they'll schedule, 20, 40, 50 people for a merit hearing. And they give you about 5 minutes or whatever amount of time they have to ask you those questions if they have some specific things they want to know. You can take somebody with you, but at this point, they seem to be mostly interested in just hearing from you.
If at the end of the merit hearing or after they finish the merit hearings, they're going to make a decision.
Correct.
Right? So at that point, they can say, yes, this is going to move on to the next stage, or no, you're not getting relief in your case.
They will actually excuse themselves and deliberate, and then they will come back and they will do a vote on the record of whether or not, and if you get 3 or more, you need a majority of the board to recommend you for a pardon. If the majority of the board recommends you for a pardon, then your application and your pardon request goes to the governor. and the governor has no set time that the governor has to respond or do anything. The governor can let it sit, the governor can grant the pardon, or the governor can reject the pardon.
Okay, so it's important to understand here, for the board itself, they're not making a decision on the pardon itself, but it's the decision to recommend a pardon be granted by the governor.
Correct, right. The board is reviewed and they believe that, if the majority of them believe you should get a pardon, then that final decision is the board's, or is the governor's. They just get to make that decision of, yes, we think you should be granted a pardon. If the majority of them do not think you should be granted a pardon at that time, then you're deemed to be denied. And you have basically three options. You're done, you don't ever have to do it again. You can wait a year and refile, or wait whatever amount of time to refile. And the third one is you could seek reconsideration. And there's actually a reconsideration section on the board website where you can ask them to reconsider based on something that you don't think they knew of or were aware of. And you would submit that, and you have a time frame to do that. The reconsideration is supposed to be done like shortly after the rejection. And again, you could not do that. You can wait. You're not, however, going to be told why you were rejected. That part is not public. On occasion, if you call up there, they might share with you where the concerns are. I know there's things that applicants don't know, but if there's a victim in a case, the victims are notified. All the DA's offices that were involved in the prosecution of the case originally, they're all notified. And they submit whatever they want to the board. And so those things are not given to you. So you don't know what those things say. And those could be the reasons why you were rejected.
Now, one of the things that I read, which I thought was interesting, is in filing a pardon, you need to understand, if it's a merit hearing, that this is a public hearing.
Correct.
So the information that's presented at that hearing is for anyone's eyes and ears.
Correct. So if it's by Zoom, which they have all been right now, the public can access those and can be part of listening and watching. In the past, they were in person at the Capitol building, up in the hearing room, and again, anyone could come into that.
Okay. So you've had your merit hearing. They've voted. 3 out of the 5 says, okay, we're going to recommend to the governor that relief be provided. Mm-hmm. It goes to the governor, and I believe you said there's no specific timeline for the governor to act upon this.
Correct.
Is there a period of time where it's just deemed not granted?
No. He or she, whoever our governor is, has to physically say, yes, I'll grant the pardon, or no, I will not grant the pardon. And you'll be notified in writing if the governor acts on your pardon. If the governor leaves, we get a new governor, another governor's elected, your pardon application is still sitting up there until somebody acts on it. I generally see them act on it. I don't think I have had any that were granted pardons or recommended for pardons and sent to the governor where the governor didn't do something. And usually somewhat in a reasonable amount of time. If you're granted a pardon, that's great. You're not done though. Now you're going to get a certificate signed by the governor saying your pardon was granted and these are the offenses, and they're going to list the cases and the numbers and all the detailed offenses. And now you take that and you're going to attach that to an expungement application in the county where the charge occurred. Because being granted a pardon doesn't erase your record, but it now makes you eligible under the Expungement Act to have your record expunged. And so now when you file for your expungement, you're going to explain that you were granted a pardon. You're going to attach your pardon application, your certificate showing that you've been granted a pardon, and then you're going to seek to get your record expunged in the county or counties where those charges occurred.
Which may or may not require another hearing in front of a judge in that particular county.
Correct. It should not require a hearing because by law, if you've been granted a pardon, you should be granted an expungement. I can't speak for every county. I know in York County they seem to get that. They understand that. If they see the application or the certificate that says yes, this person was granted a pardon, and you filed your expungement properly, you should be, it should just be signed and granted, and you'll receive that information in the mail. Or if the judge does schedule a hearing again, you'll go to court and it should be granted, and you'll be again sent the paperwork.
So this expedited process, we've talked about a lot of things that need to happen here. The approximate timeline from the time that I apply my application to the time that I'm granted relief from the governor, approximately how long does that take?
So with the expedited, I've seen that close to the 2-year mark, whereas the regular pardon process is closer to 4 years. So it should cut it in half. I know that they've hired additional staff to process the applications in general, and I assume that that was done because they were trying to move the expedited pardons. And the process that we've talked about, and you've asked questions, that's the pardon process for everybody. The difference being the expedited pardon, they're going to, same application, but just check that box, expedited, and again, we're talking about you can't choose to be expedited. You have to fit the criteria, which is the marijuana-related offenses.
Excellent. Well, Susanne, thank you so much for your information and your knowledge regarding the area of pardons. That concludes our Legal Lines. Legal Lines is brought to you by the York County Bar Foundation. You can find us at York County Bar Foundation or the York County Bar Association online and our various social media platforms. My name is Glenn Smith. I'm the host of Legal Lines, and we'll see you next time.